Let's do it.
Welcome everybody to this panel on cannabis patient protections. As everyone here I'm sure knows, the Teacup program has been in place for several years now and was expanded in the last legislative session. I think it's encouraging that the legislature is showing a commitment to increased access to medical cannabis to the extent that many folks are saying that Texas is now the 40th state with a somewhat comprehensive medical cannabis program and regime. That word regime, though, really is the key, because having a program in place does not necessarily put in place the full architecture of laws that are necessary for patients in the Teacup program to live lives. Laws that govern their life at school, at the hospital, in their workplace, in their family lives. And there's considerable number of areas where vestiges of the decades and decades of a full prohibition regime are still interfering with the ability for people to live their lives within those legal frameworks while being lawful participants in the Teacup program. And so if the legislature is committed to actually making the program work, the hope would be that attention will be paid in the coming session and in future sessions to harmonizing the law across all the various areas that it can be effective, whether employment, family law, and even school law. And so we have a panel assembled that bring various areas of expertise to that question. Myself, I'm Holt Lackey. I have my own law firm here in Austin. I do primarily employment litigation, and then some general business litigation and consulting as well. We have Liz Cross, who's a pediatric nurse practitioner with the Child Neurology Consultants of Austin, and she can speak somewhat to some of the challenges that pediatric Teacup participants face. Chase Bearden is the executive director of the Coalition of Texans with Disabilities and has comprehensive expertise in the areas where Teacup participants are still facing challenges from vestigial restrictions. And Jason Kercheval is a family law attorney whose practice with the Ramos Law Group is primarily in Montgomery County, Texas. And he can speak to how some of his clients and others that he sees in the family court process are dealing with unintended consequences of being Teacup participants that are having adverse effects even while ostensibly they are lawful participants. We're joking we managed to seat ourselves in the opposite of our photos, but if you can just sort of mirror image yourself. And I think we're gonna, I'm gonna turn over the floor to the panelists to each kind of have their, opening statement and some time. We'll have a discussion, and we will open the session to questions toward the end. So that's the plan. I guess, Liz, do you want to go first?
I'm Liz Cross. I'm a pediatric nurse practitioner. I work here in Austin for a pediatric neurology group. And in 2019, I left the hospital and opened a CBD resource clinic called CBD Resource Clinic because it was really an educational idea to be able to help educate patients for their families to be able to gain access for the pediatric patients. I, as a nurse practitioner, am not able to prescribe in the state, so I make recommendations to the doctors, and then the doctors are able to prescribe on my behalf, basically. But what I've done is be able to help families who would love to have their children have access, get answers to some of the questions that they have, understanding the Teacup program better. So advocating for the kids to be able to have access to this. And then second part of that is also in the classrooms. So, dosing depends on what the child needs, but over the years, I've had more and more kids who could really benefit for a midday dose. And of course, where are they? They're at school. And a lot of the times, the school doesn't want to give it. It's not FDA approved. So currently, the way that their policies are written is that FDA approved medications can be and should be given at school by nurses. They have updated their policy thanks to, I hope, some of my work. They have TASB, the Texas Association of School Boards, which has updated it. Now it does have a double negative in their statement that says something along the lines of they can't not help or something like this, right? So they're supposed to, at all costs, try to allow students access to their medications at school. There are loopholes that you have to go through because it's not FDA approved. And so I go out and speak to some of the different school groups, and I talk to the school nurses. I've been invited to the Texas State Nursing Board Association, something like that, to present to all of the Texas nurses on a statewide level, and then also their administrators. So trying to educate them, mostly that's what it is. It's the stigma behind it that people are scared of. It's not necessarily anything more than that. So educate them on the program and really try to support the kiddos and have them understand that, this is something that is helping them through their day, and why would we prevent them from having access to it? So happy to answer questions later, but we'll keep going down the line.
So my name is Chase Bearden. I'm the Executive Director of the Coalition of Texans with Disabilities. CTD's been around since 1978. We're kind of a statewide advocacy organization. We cover a lot of different issue areas for the disability community. And most of our time is spent in the state capitol working with legislators and then state agencies. Over the years for me, we've gotten to work on this issue with Teacup since the beginning in 2015. When a lot of the parents were coming in to help get access for their children dealing with seizures. And for me, it actually benefited me later on, where when I was taking, you can't go 30 years in a chair after breaking your neck and not ending up on some kind of pain medication. Doctors were just basically handing me more and more pills to deal with pain through the day. I was working full time. I think working in the Capitol full-time means more like 10, 12, 13 hours a day. But I was taking up to 6 hydrocodone a day. So, after 10 years, your body just becomes, dependent on it. And it wasn't even benefiting me at that time. And, I was able to actually find cannabis drops that ended helping me work my way off the last bit of hydrocodone and get off of them and not have to take them anymore. And that benefited me a lot. It actually benefited me at work too. My brain was much clearer not having to take that much hydrocodone in a day and try to see the big picture and everything. So for our organization, I got to personally see the benefits for me. Also for a lot of our members. I mean, when you're working with kids that you see, who are dealing with 20, 30 seizures a day, and you talk to their parents, and now they're down to 1 a month, and the kid's going back to school and actually active. Those are stories and situations that you see the benefit, the real benefit in it. But over that time and that period that we've worked on this and tried to expand the medical side of the program, and the reason we worked on the medical side was that we had to make commitments to legislators early on that we weren't coming back because they weren't there was a handful of votes needed to help move it forward. And, when we'd go in, they were like, well, y'all are just trying to do this so that you can then expand it to, just full on. And we were like, no, our commitment is to medical. We won't come back and ask for any more than that. So we had to make that commitment. So we've only worked within the medical realm of Teacup. But over that time, we've worked and we've run into some problems. And I think the main problems being employment afterwards. people having questions about, okay, I've gone and gotten the doctor to sign me up, and I'm going through the process, but I found out that HR has a problem with this. We're still having, have a P test, and I failed it. What do I do? So employment, there's a lot of issue areas around that. I think with families being afraid, if one family member is using it, is that going to affect them in any other way with CPS or other issues? So there's still a lot of those kind of hesitations from people, but also from businesses. Both Liz and I got to work on the Teacup work group with the Department of Public Safety for quite a while, and it has recently wound down. But I think that was helpful to kind of help move some things forward. So we've had good access over the years to try and improve the program, but I think the program still needs to go a lot farther to really focus on patient protections.
Jason?
I'm Jason Kercheval. I'm a senior associate attorney and kind of the head of, I won't say head of litigation, it's not an official title, but I mentor all the other associates at Ramos Law Group. We're based primarily out of Houston. I run the Montgomery County office. And so Holt was right. My personal practice is primarily Montgomery County and a little bit of Waller, Grimes, Walker, San Jacinto, and Liberty counties. And my main focus, particularly for the last 10 years, has been family law. I'm essentially only practicing family law now. Previously, I did do some criminal defense work and was the defense attorney for the Montgomery County Veterans Treatment Court. So that kind of started me down this path and getting familiar with Teacup at that point. But what really sparked my interest and caused me to get a little bit more involved is this past year I did have a case it was the first one I've had where my client was a Teacup user. He was fully registered, went through it all the right way. And the short answer is that there is nothing in the family code that protects you from somebody believing that any use of THC or cannabis products of any kind is therefore detrimental and potentially harmful to the child. The family code leaves the judge with an incredibly wide level of discretion as to how they want to determine what is in the best interest of the child. And in my particular case, it appeared to seem that once we had gotten all our ducks in a row, got the records from the dispensary, got the doctor or the physician deposed, and got the records from him, and we're able to present all this to the court to show that this is legal use of low THC cannabis. It is causing him to test positive on urinalysis, but interestingly, it hadn't been testing positive on hair follicle tests. So the other side didn't know about it. As soon as that urinalysis occurred, the other side found out about it. They tried to take advantage of it, and were able to. My client was essentially given, not explicitly, but implicitly, a choice between taking a medication that had shown incredible improvement for him, which, as a side note, he's a veteran with post-traumatic stress disorder that actually got him justice involved. I met him through the Veterans Treatment Court about a decade before this litigation. He had been a very violent, out-of-control person on normal pharmaceuticals. He is not that person now, but that really didn't matter. What mattered was the mother of the child had an issue with his use. And so he had to decide whether or not he would ever be able to have overnights with his 9-year-old daughter, or whether he should continue to use a medication that made a big difference in his life and had dramatically improved his quality of life. And that's a choice that I hated that he had to make. But that is a choice that anyone who is using this, if you're outside of, if you're outside of Harris County, Tarrant County, Dallas County, Bexar County, or Travis County, and you're a Teacup user, this could be a potentially huge issue for you in any family law matter you have. And in those counties I listed, it might still be a huge issue because there's nothing out there guiding these judges. The judges can decide it however they feel fit. And their review on appeal for that sort of a decision is abuse of discretion, which for any of you who know anything about how appeals work, that's basically they can do whatever they want to and the appellate court's not going to have a problem with it. It's got to be something that's so out of line with the facts that were presented that no reasonable person would conclude that was the proper outcome. Any reasonable idea that an appellate court could come up with that that judge made the right call, they're going to bless that judge's decision. So the people who get involved with the teacup program unfortunately do have to consider what happens if divorce, if my ex-wife or the mother of my child or father of my child finds out I'm using this, are they going to have a problem with it? Do I tell them about it? Do I let them know ahead of time, even though it's protected health information? Should I go ahead and preemptively say, hey, I'm thinking about doing this? These are all questions that there are no easy answers to. And it's something that people need to understand before they get involved in the program, which I wholeheartedly support, by the way, and think should be further expanded. And nonetheless, there's some work we got to do in the family arena to make sure that that decision doesn't then basically make it where you're a part-time parent, more so than a standard possession order would make you.
So about half of the states that have a medical cannabis program have codified some version of employment protection explicitly saying that participation in the program cannot be the basis for discrimination in employment. Is that kind of framework of, participation in the teacup program alone shall not be the basis for X, kind of is that the operative sentence that, shall not be the basis for a determination about best interest of the child, or shall not be the basis for discrimination? Is there something that, rather than going through the much more comprehensive task of looking at the family code and the health and safety code, something that could be put right in the occupations code with the rest of teacup that preempted mere participation as consideration in some of the adverse decisions that currently participants could be subjected to?
I think it would be very helpful. Another area where you don't even think about it is we had a close friend and a member of the organization who is older, has Parkinson's, wanted to spend time working at one of the hospitals, volunteering to help with some of the babies. Is an amazing person, and absolutely shouldn't have been discriminated against in that reason. But after going through the whole process of, and it's not like you can just randomly volunteer there. You go through a very in-depth process and training and everything. They denied her after a urine test, even though she was able to prove that she was in teacup and that she had gone through the doctor and, has Parkinson's. And that alone, would help in a situation like that, because no one should be discriminated against just on the basis of you being in the program, because it's one of the medications you're taking.
And we
There's
wouldn't
no
have tested
difference.
for pain medication. She
No,
would have been
there's
able
much
to rock
worse
that baby
medications
all
you could
day
be
long
taking.
on an opioid, right?
That was a question I wanted to raise.
No,
Is,
we don't test
for each of the areas that y'all are talking about, if you had prescribed Schedule II opioids, would the same kind of challenges be present for patients in those areas? No.
So in the family code, and this would be I would push back on your suggestion of just throwing in the you can put it in the occupations code, it's not going to be seen by family code. The judges, would we eventually get connected up to it somehow? Yes, but this is a provision that needs to be put in the family code. There is one place in all the family code where low THC cannabis is mentioned, but it's only with regard to when the state of Texas is trying to take your children away from you during an involuntary termination. It is explicitly stated that cannot be a rationale for involuntary termination by the government. There is nothing that stops the other side in a private, non-government, mom and dad fighting each other situation. There's no guidance whatsoever within that. So I do think that some sort of provision like that should be in place. You know, you mentioned opioids, and another one that we hear from time and time again is Ambien and drugs like these sleep aids that we know potentially have side effects of sleepwalking, blacking out, these kinds of things. My experience, and my experience really is all I can speak to here because there's not really much guiding case law out there, but my experience is that in every case, except for the use of cannabis, the question is, well, what is the use of this drug doing that's causing potential problems for the child? What I'm seeing more and more often with cannabis is they don't ask that second question. Okay, well, what is the use of your low THC cannabis? How is that affecting your ability to be an effective parent, to monitor your child, make sure that their needs are being met? We don't even get there. It's just the use of it, and then the other side says, I think that's bad. And that's generally enough, and that is because of the years and years of prohibition. I'm hoping that we're going to start seeing judges get more educated on it. But I do think there's probably going to need to be some statutory authority put into place that specifies that there is the mere use of any substance, because there are lots of medications that can have wild side effects potentially, but can also be very therapeutic. Any substance legally prescribed to a person, the mere use of it should not in and of itself affect their ability to be as much of a parent as otherwise. It should be the effects that medication is having on the individual and how that presents a threat of emotional, mental, or physical harm to the child, inability to properly supervise, these kinds of things that we know are necessary to be a good parent. Our focus needs to be on actions, not on the use of a particular substance, any substance, really.
When was that reference to low THC cannabis added to the family code that you mentioned?
That is a good question. I do not know. I suspect it was probably in 21, but I'd have to look that up.
Okay. And so is it the case now that if a call came into CPS that either a parent or a child was a participant in teacup, is there sufficient statutory authority that is automatically a priority none, call goes no further?
No.
Okay.
The provision that I mentioned to you is only dealing with a parent who the government is trying to terminate their parental rights.
Okay.
That is the only situation where low THC cannabis and the use of it is mentioned in the family code, and it's the only time in which it says you can't use that. And it doesn't say the use of it and then also effects that it's having on the individual can't be used. That could be an issue, but just the mere use alone cannot be a rationale by which the government can try and take away somebody's parental rights.
And I assume termination of parental rights is a step far beyond government taking some action that interferes with the custodial or possession rights.
Correct. And the standard, the burden of proof for termination is clear and convincing evidence, which is one step below beyond a reasonable doubt.
Right.
But when CPS gets involved, when there's concerns about whether a child, things like safety plans and these types of things you put in place, that's not a clear and convincing evidence standard.
Yeah.
That we only get there when we're saying, okay, we've done what we can, it's time to cut this person out of the child's life forever.
What about the child's participation?
Right. So, and from a child's perspective, there is also no protection in the code right now. This last legislative session, I worked with some of the different people who were helping write the bills, and every time they would write a revision of it, we kept inserting language that tried to protect parents who had their children on teacup, THC, CBD, that they wouldn't lose their rights, or they wouldn't be penalized, or they wouldn't go to CPS and have a whole case, brought up against them because their child was properly enrolled and being given teacup products. And every time it was struck through. So every time that language was returned to us, and that was removed from the bills every single time. So we did not successfully get it on this year. We will continue to try, but yeah, currently there's no protection for the families. I don't make that a huge scene with my families, but of course, if they have a problem, and I have been asked by lawyers, by judges to write letters that proves that they were a patient in the program, which again, to me, shows that they don't understand the program, because me writing a letter is not the same as asking DPS, who's in charge of this program, if they are a patient. You know, maybe I'm their next door neighbor, and I'm happy to write a letter that helps them, you know, get rid of the problem. They shouldn't be asking me, in my opinion. They should be asking DPS.
You might consider in the next session that there was a Section 37 Texas Bill of Rights, the constitutional amendment, which for other reasons as a family law lawyer I'm very, very concerned about. But from the perspective of you guys, that there was the Parental Rights and Responsibilities Amendment to the Constitution. We don't know yet how that's going to play out from a legal perspective, but if you read it, it might provide you the top cover you need to say a parent gets to make decisions about the child's upbringing. I mean, that is explicit now in the Constitution. And that may give you some more traction in the next go-around legislative session.
I will say, I have had families who've had CPS called on them, usually primarily by the schools,
Yeah.
they have all been dropped. So CPS, at least in the counties that we're mostly talking about, I'm mostly Travis County, Central Texas, and thus far, every case that has been brought to my attention has been dropped.
Okay.
But that's not something people should ever have to
They
go
shouldn't
through.
have to go through it.
And that shouldn't end up on
Correct.
their record no matter what, because the
Correct.
moment CPS is called,
It's on
that's
the
on
record.
your file.
Yep, absolutely.
And, you know, at the end of the day, that's not something you want to have.
Right, and it was also on their file when you guys were first working on it for epilepsy treatment, and they were getting it from Colorado and using it anyway, and that was getting put on their file then.
And I suspect that CPS will handle those issues very differently in Lubbock or in Abilene or in Tyler.
Potentially, yeah.
You know,
Absolutely.
the more rural you get, the more disfavorably the use of cannabis in any way, shape, or form tends to be. There are obviously outliers everywhere, but that's been my experience. And you know, I'm in Montgomery County. We're a pretty big county. I think we're within the top 10 in population in the state. But there's a big difference between those 6 I mentioned and everybody else. And from the perspective of cannabis stuff, even the bigger counties like Montgomery County seem to be more in the rural mindset than the urban mindset. And so it's much less acceptable.
And I think that's why working on patient protections next legislative session is so important, because at the end of the day, when someone joins Teacup, you know, and I think we talked about this on our call, the state passed a program which, in all intents and purposes, said we are allowing this for medical use prescribed by a doctor for a patient. The average Texan takes that as, okay, then I can participate in this and I'm safe. But what they don't realize is that it got created, the whole practice did, but none of those protections were put in anywhere. And I think that's something we have to remind people, is that you are having to make a choice and you're having to look at where you live. And we can't have a patchwork of, you know, courts and counties participating in it differently if we don't have it very clearly spelled out so that they understand it, so we don't have parents having CPS called on them because they live in a more rural area, but it's benefiting their child. You know, at the end of the day, you know, we got into this part of it because we wanted people to participate and work with their doctor and to be open with others around them, not to push it back into the, you know, alleys and,
Closet,
you know, keeping it quiet, because really it has been a benefit for so many.
And, yeah, on just the highest level kind of political theory, you know, perspective, if the legislature wants to adopt a policy, the legislature is supposed to set that policy and set it up to succeed rather than leaving it to the discretion of school nurses or family court judges or CPS agents, dispersed around the state, applying it according to their own judgments and whims. I'm actually curious, are there any other categories, such as Schedule II drugs, that school nurses even have discretion not to administer if lawfully prescribed?
I can't speak 100%, but to my knowledge, as long as it's FDA approved and prescribed by a doctor, then they are legally to give it at school if they're told to.
Mm-hmm.
And that's where we fall short.
Have there been any, does that become a licensure issue at some point for a nurse who's refusing to follow essentially a doctor's orders?
Yeah, so Texas Board of Nursing is one that I used to, for funsies, call and just ask, can a school nurse, give this if there's a doctor's order to do so at school? And I keep wanting to get the answer of, yes, it's approved, it's a Texas-run program, we support our nurses in giving that. And so far, I have still not gotten an overwhelmingly yes. Instead, it's use your medical judgment. And so when I go out and teach and the educational level at these schools and tell them what their options are, and it says in TASB that they should provide this medication to their students as best as they can, I also have at the end of my slides, I say, if you as the school nurse does not feel comfortable, that doesn't mean that your kiddo doesn't get it at school. It doesn't mean that your whole school doesn't get it. What that means is we have to find someone else who's willing. And what we all know, in the medical world, we all have heard about the Good Samaritan clause, right? If I'm walking down the street and I do something outside of my medical practice, I can be held accountable. If you don't have a medical license and you decide to be MacGyver and use a pen and make a trach for somebody on the street, you will not get in trouble, right? Because you thought you were doing something to save their life. I, on the other hand, could get in trouble because I don't have approval to do that. It's the same thing. So in the schools, if a nurse feels like they are jeopardizing their license, they don't have to give it. But a principal who doesn't have a medical license to lose can absolutely give a medication. And so that's what usually happens. We have primarily the special ed teachers give it. If the nurse is saying, I can't, I'm worried. But I do my best to try to answer questions. I also will sometimes encourage them to call the Texas Board of Nursing and ask for themselves to be able to work through that process together. But there's almost always someone at the school who'll give it.
While we're primarily talking about the Texas legislature and how it can, put its full support behind this program that it, at least de jure ostensibly is supporting, is the elephant in the room on a lot of these issues the persistent federal prohibition? Is that what gives a family court, the ability to say that this is still, is that what gives a nurse the ability to say that, it's state legal, federally ambiguous to illegal, therefore I'm concerned, and does that allow more, does that ambiguity and that disconnect allow some of this disparity to creep in? And, not that we're going to go fix the federal law immediately, but, is that kind of the elephant in the room in a lot of these discussions?
I think it always turns people's heads and makes us question.
I'll be honest with you, the only way I could answer that question is if I had the ability to read the mind of the judge. Because ultimately that does not matter with regard to a family court judge's interpretation of it. Their lodestar is the best interest of the child. And there are Hawley factors it's a laundry list of things that they should consider, but they can kind of consider anything that they feel is rationally connected to that question. Mm-hmm. So is that a factor in some of the judges' thought process? Probably. If it suddenly became totally legal from the federal level, would that change the outcome for a lot of the judges that I have concerns about? Probably not. Mm-hmm. Because it's not about the legal, I mean, teacup is clearly legal. None of the judges are gonna stand here and say, well, I just don't think it's legal. It is, it's clearly legal. That's not what they're trying to answer the question to. They're trying to answer the question of, is this person's use of this substance not in the best interest of the child? Is it in some way, shape, or form creating an environment, exposing the child to potential, poisoning, or, you can see how just when you've dealt with 100 years of propaganda, there's a lot of that that's just gonna sit there. And how do I know which things are bouncing around in that judge's head that aren't being presented in court, but are nonetheless going to be a part of how he answers that question? Yes, but really no.
Right.
I don't think that's really the issue. The issue here is that the family code gives the judge absolute wide discretion of it, and you're seeing those stigmas are still affecting the way that they analyze the question.
That's how I was gonna answer, it's stigma. I don't
Yeah.
think it's federal, I think it's stigma.
And we
Well-
did run into,
Yeah.
though, I do have to bring it up,
We joked for a second, but we'll say it out loud.
yeah, I'll be the one that says it out loud.
I said it when we privately talked.
Yeah. When we were attending one of our teacup work group meetings and
DPS.
with the past director, she had attended a conference and there were some judges speaking, and one got up and he was talking about cannabis, and he was going to be hard on cannabis, didn't care about where it came from, who was on it, and there's no cannabis allowed in the state of Texas, and we need to stick by this. So afterwards, she went and approached him to talk to him.
Introduced herself, what she did, where she was, and DPS,
From
yeah.
public safety, and that, she was the head of Teacup and everything, and he goes, I don't recognize it and I don't believe it.
Not in my courtroom.
Not in my courtroom. Federal law says marijuana is illegal, and that's what I'm going with.
Yeah.
And he did.
You will see that in the smaller
And it was a
rural
small,
It
counties.
rural
was.
town.
It
She admitted
was.
to it, yeah.
You will see that.
But that's,
And she
That's
said she didn't
not-
even know what to say. She was just like, but that's not how the law is written. And he
Yeah.
just kind of said,
I don't care.
my courtroom, my rules, kind of thing.
And
So, yeah, he was
And the worst
using
part
that
about it
representative.
is typically when we have an example of a judge that is completely ignoring statutory authority, there is a remedy to that called a writ of mandamus.
Right.
But how do you mandamus the best interest of the child?
Yeah.
You can't. There's no way to do it. It's too fuzzy of a question to answer. So that's why I genuinely believe that the only way to fix it in the family code is specific statutory authority that makes it absolutely clear that mere use alone cannot be the reason. It's still not gonna fix it in all these counties, but at least it's gonna make them jump through a bunch of legal loopholes and explanations and thought processes to try and justify their bigotry against people who use.
And presumably prohibitions on considerations of specific, topics exist for race, for, First Amendment.
Right.
Religious or speech rights, political views. Presumably there is a regime that more or less, when there is a prohibited factor, can be reviewed even in the broad best interest of the child standard, and even while that broad standard might allow judges to launder prejudices in, they still can't even say it or make it a part of the hearing, and that's the difference, correct? I want to quickly ask if anyone on the panel, before we turn to questions, if anyone has questions, sort of get my attention while I ask the panel. One topic we haven't covered is gun rights and how TCUP affects Texans' gun rights. And, if anyone on the panel would like to address that issue.
I think you did a great honor.
Well, the one thing I'll say is, I know we've run into it with people who work at DPS and others, where at the end of the day, people aren't joining the program because they have to, when you go to fill out your application to purchase a weapon, at the bottom, it does state, you know, are you using cannabis in any way, basically? And if you sign yes, well, you're not gonna get it. And if you sign no, you know, even though you're thinking, I'm taking a a medication, so no, I'm not out doing drugs, then you just committed a felony, basically. You signed saying that you were not. So you have a lot of people out there who are still not joining the program, or basically, you know, afraid to, because they don't want to have to write that on there.
And is that question a national ATF question, or is there anything that can be done at the state level about that question?
I believe it's national.
Yeah, at the end of the day, I don't know what we can do besides having, you know, the state.
There's some things.
Yeah, I mean,
Yeah.
the state's done its more than once, fixed things at the state level when they needed to, but, you know, I think this is one of those areas where setting people up, you know, to commit basically a felony when, you know, they have the right.
Right.
We're doing it the wrong thing.
And
No,
when
and,
we
and
mentioned-
that one is just particularly astonishing because, you know, a lot of the topics we're talking about are things where you can explain it by, well, Texas is new to this program and we just haven't figured out all of the ramifications and other areas that need to be tweaked. But Texas being new to this program on that one seems like, how has this not been figured out the first time that, you know, the
Well,
gun
and-
rights folks found out that it was happening in a state where people were lawfully taking cannabis?
I think the question here for us was DPS is in control of the guns and these license, right? And so
Both
they,
lists,
they're
yeah.
both, they're in charge of both. And so the question is, how come you guys didn't see
They
that this
didn't-
would be a problem?
they didn't
And
want to.
their response to us when we first asked them about it on the board was, we actually don't talk to each other. Like, we're not comparing, we're not
They're
here
not
talking
comparing the
about it.
list.
They're not comparing the list, they're not trying to find, you know, people who match up on both lists.
But it doesn't
And
mean they could.
It doesn't mean they couldn't. And that's the fear of, you know, the populace, is because we know that they're being controlled by the same group. And so we assume that that means the left hand is talking to the right hand. While we were told they're not, they can. And so there's the problem.
Yeah.
Can I throw one thing out there before we jump into questions, not related to what y'all
Oh,
just
yeah.
said? As a family law litigator, and there are a bunch of my, you know, cohort out there all across the state, these teacup cases are going to become more and more common in family courts. They're still very new. As far as I'm aware, there is no appellate law at all on it. So this is still very novel in the family arena. But in my particular case, I had the damnedest time. We probably spent $5,000 trying to get a physician served with a subpoena for a deposition. Everyone out here and everyone that you interact with, if you are a dispensary that's licensed under TCUP, or you're a physician that's licensed under TCUP, please understand we need you guys. And we need you to please work with us. Because we are very persistent people and we will get you. But if you work with us, it's going to be much more pleasant. And there's not going to be a way to avoid it. A court will order you to sit down for a deposition. A court will order you to come and testify in court. We don't want to put you on the spot. We don't want to become adversarial. But if we have to, my client's more important to me than you are. And I will have a PI sitting outside your door at 2 a.m. waiting until you walk out your door, and we will tag you. So please, don't do it. Work with us, okay? We're not bad people. Well, most of us aren't. But that unnecessarily increases the cost of litigation for your patient who just is trying to be with this kid or her kid, okay? So please spread that word around. We won't bite hard, you know, and it's not really going to be a question about you. It's going to be a question about your patient. Okay? Sorry.
All right. Does anyone have questions? I see one in the back row.
Holt, you addressed federal, but I want to ask a little bit more specifics on, like, if, you know, Schedule 3 or Schedule 6 or deschedule, any of those things would affect any kind of, I know, Liz, my son's a teacup patient.
Yep.
And so, early in teacup, we didn't have an issue. I had a great relationship with the nurse, so we didn't have an issue with giving things at school when I was giving it at school. But I did remember, I don't know, 1 or 2 times that I had to take them off campus. And the reason for that was because schools get federal funding. So I know that, the federal funding, any place, and I've had conversations with different, colleges and universities about including it, cannabis education in their curriculum, and it's always an excuse, we receive federal funding, so we can't. And, apparently there's other places that receive federal funding that are doing this kind of thing. So maybe it's just misunderstanding or an excuse or whatever. But would legally any of these different scenarios of schedule status affect any of the things that we're discussing today? Federal funding to schools or universities, statutes with family case law kind of stuff, firearms.
So the easy answer from the family law side is the answer to your question is as varied as the number of judges there are in the state. Unless and until there is specific statutory requirements that limit a judge's ability to decide that however they want to, the only impact that federal scheduling is going to have is longer term indirect as society and culture becomes more accepting of the use. Then you'll start to see judges shift because we'll have new judges coming in and the opinion will change. But depends on which county you're in is the short answer to what you're asking.
And so that would be to advocate for any substance, like you had suggested earlier, to
And
be included.
I think that from a political standpoint feels like the easier way to go with it because you're not singling anything out here. You're saying, no. People take all different kinds of substances as prescriptions. Let's not assume that the mere use of it is a problem. Let's show me the real evidence that it's a problem, then we can talk.
I will say in the employment context, Labor Code 21.120 specifically references Schedules 1 and 2 as in saying that it is not an unlawful employment practice to discriminate against an employee who takes a drug listed in Schedules 1 or 2 unless under a doctor's care, essentially as authorized by state or federal law. And so ironically,
Federal housing benefits also.
Employment is an interesting case in that the federal ADA does not include an allowance for as allowed by state law. And so a person who was in teacup and was discriminated against on that basis would likely not have a federal claim because the federal ADA does not recognize the state lawful administration by a doctor in its analogous provision. But the state ADA, Chapter 21, does say as authorized by state or federal law, and it would seem that folks in the teacup program are within that safe harbor from the employer safe harbor. But descheduling would take that completely off the table.
So I'm just curious about, since you mentioned that, about the employment, but how about federal housing? Is federal, I'm assuming what happens is there's no communication there, but federal housing, if you're using a Schedule 1 or 2 substance too, right?
I can't really
I
speak
can't
to
really speak
it's
to
not
the
really
housing
within
policy.
my wheelhouse, so I don't
Yeah.
know the answer to that.
Okay.
Are you referring to let's say, for example, if you take Adderall and that's legal, then you would be technically, the medical board examiner is supposed to rule it out from a drug exam? Is that what you mean?
No, to qualify for federal housing money or federal housing,
I guess I'm referring to employment.
Subsidized
If someone is
housing.
employed and they're in the teacup program, do they have some sort of protection in terms of the medical board examiners?
So if I take Adderall, so when I go in to take my urine test at the doctor, it's gonna show that. And when I was in teacup. I had to explain to my doctor, I had to show him a letter, I basically, my doctor didn't have a problem with it, but the higher ups wanted it in the file in case DPS ever came to pull their files, that it was there, and they were okay with it. But, because it's prescribed by the doctor, even though my test always shows when the labs come in that it's hot, once they see those two, they already know it's in my file. So those are pushed aside and it can't be used against me.
But is that the same with like teacup, like medical cannabis?
But in employment, depending on where you're employed, so it could be that, the place you work, their insurance company is, has a no substance kind of policy. Especially if you're driving a vehicle or something like that. So you could run into that. But at the organization I worked at, we changed our in-house policies after we started supporting this. So for us, it wouldn't make a difference. Yeah.
Okay.
Sure.
Yes. Okay, so this question about the teacup, the lab testing. Okay, so I know initially the DPS released like only 3 producers. Now I think at the end of last year released 9 producers. So the policy and the regulation, as I know, is like those manufacturer, producer, or licensees, they make their own product, and also they test in-house, and provide a test report or call a certificate of analysis, like COA, to the market. But however, do you think about this? There is a conflict of interest. Like you make product and you test it, and you will test. Oh, my test is good, or my test is not good. It's something like the football player also you serve as a referees of the match. So it's like now it's really conflict of interest. So how do you think about the DPS consider this one? And also remember today the header also mentioned about like independent lab testing, right? Independent. See about like the Florida state, right? Florida and Oklahoma and Arkansas, they have their own independent lab, and they provide this independent testing and to eliminate this kind of like the conflict of interest. So my question is, does DPS realize these things, and do you have any kind of thought or kind of like the plan to overcome this challenge?
And I'll have Liz answer too, but the one thing I will say is working with DPS and the 3 licensees is how often DPS is in their building. It's not like once a year kind of thing. It is multiple times a month, and they're showing up with a team, and it's significant. They are highly regulating it and being hands-on. Will that change as there's more licensees and how spread out they get? I don't know. I don't know how much more they'll hire. I do believe that DPS was doing some random audits on those tests to make sure those tests were accurate.
Yeah.
I don't know how often, but I do know there is a big push from a lot of people for third-party testing that's independent of everyone. I think for my organization, when we got into this, the reason we wanted a medical program is we wanted to know exactly what was in that medication, because we were looking at it as a medication. Because when you're working with your doctor and you have a significant health concern or health issue, and you're taking multiple medications, not just your random ones, but ones that actually can have a lot of effect on your body, we wanted to make sure that that person, when they were getting it from these licensed programs, that when it said 10 milligrams and it had exactly this and this, they knew exactly what they were getting. So that way they didn't have any contradictions or effects on any of their other medications, which there are some, no matter what you're taking, So I do know for us, having that accurate, knowing exactly what you're getting is important, and I think that should be across the board for everyone, knowing what you put in your body.
As a medication, right? Like teacup, right? Medication. I think random also not enough. I think every single batch should be audited. In that case, I think only the Texas allow producer to do their own lab testing in-house. Other states, I think all of the other states which legalize the medical, they always have their own independent lab. I think only Texas is the unique state allow producer to do lab test in-house. And you mentioned random. I think random is not enough. It should be every single batch, every single moment we need to monitor because that will be consumed by patient.
I agree.
That should be very important.
And I think they will get there as it grows. I think it was just, honestly, in those first 10 years, it is drug on to get going.
Yeah.
And I think that played a big
And
role.
it's
Well-
what we've been advocating for since the beginning in the state. But, even when you have third-party testing, you're not free from issues, They have issues in other states with
Yeah.
third-party testing, with lab shopping and all kinds of.
So that's
They
why I
have
was,
issues with that in every kind of
Yeah.
pharmacology.
Yeah.
Right.
with the third-party testing, and I can speak so I used to be on the medical board at Texas Original. So Texas Original Compassionate Cultivation, which is like 70% of the market share right now. They're the biggest ones, the biggest dispensary operators right now. When I was on that board, and I don't believe it's changed, their in-house lab was not their lab. It was a third-party lab. I know it was in their building. I understand the conflict of interest that can arise there, but they were different lab coats, they were a separate entity that was occupying a space within to be able to do daily things. And I can tell you that if you open up their logbook, they would often have 2 or 3 tests because there was a color discrepancy that they didn't like, that they were still sorting through. So they were very transparent and very open and would always bring it to it. And I've seen them throw things out. So I do think that they try really hard. And from someone who treats pediatric patients, where my main concern is consistency, I have never had a patient come to me and say, this batch was different than this batch and this is why. The only time that's happened is when they actually changed it and they went from a 5 milligram gummy to a 10 milligram gummy and the patient didn't know. That's obviously a big deal, right? But I think that consistency speaks loads because I'm talking about microdosing these kiddos. And that's not the consistency that you get at a regular store, typically.